This is case number 21, 160918. This is William Buford versus Progressive Marathon Insurance. Today is the date and time set for a pretrial conference in this matter. Your appearance for plaintiff in this matter.
Good morning, Your Honor. Doug Karaskevich, PA 1458, on behalf of the plaintiff.
All right, thank you, counsel, and good morning to you. For Progressive, please, your appearance at this time.
Good morning, Your Honor. Lana Boff on behalf of the defendant. However, we're a defendant for Allstate. Progressive has been out for a little while now.
Gotcha. I see that. Thank you. Now, counsel, your P number, if you will, for record.
P83946.
All right, thank you. See whether all right, so there was a guardian, there was an issue with the guardian regarding this matter. Somebody update me on what the status of things are.
Yes, Your Honor. So Destiny Tompkins, it was the guardian that was appointed by probate court, and I had some issues getting a hold of her, but I was able to get a hold of her a few weeks ago and let her know what was going on and that we needed her to participate in this case, and the case caption had to be amended to reflect her as the guardian for Mr. Buford. She said that she needed to talk with Mr. Buford and then she'd get back to me. She never did, so I did contact her the other day, and I reminded her that, you know, as a guardian for Mr. Buford, we would need her to participate in this case in order to move forward. And she advised me that she has no interest whatsoever in participating in this lawsuit, which to me, I have no idea why, as you know, someone who has been appointed the guardian by the court, and it wasn't even the first guardian. This is the second guardian. She petitioned to be his guardian and now is showing no interest into, you know, participate in this case. So at this point, my hands are kind of tied. I don't know if we should, you know, have her come before the court or have a new guardian appointed, go through probate, or I'm not sure.
Madam Counsel, your thoughts, Vicky.
I mean, quite frankly, our hands are tied. Allstate's not able to move forward without the guardian in this matter, and we've now appeared a number of times before you trying to obtain a guardian. So I think we're at a loss. I mean, my position would be that we dismiss. We're not able to make any progress.
Yeah,
I think that's putting the cart before the horse, Your Honor. I mean, they want the deposition of Mr. Buford. He's not able to do that. So they want the deposition of a guardian who's only going to tell them what his current status. They're not going to know anything else. So I think we do need a little extra time to try to figure this out. I'm thinking I need to petition the probate court to appoint a new guardian if Ms. Tompkins isn't willing to participate and do her duties as his guardian.
Yeah, it would seem to me that I can see where counsel would make the petition to dismiss. Obviously, the guardian is a person who at this time has a legal right to act on behalf of the plaintiff in this matter, and as such, she seems to be interested in abandoning this case, but that would seem to perhaps be a breach of her fiduciary duties, particularly where counsel for plaintiff believes that there is a plausible cause to action to advance here. So it does seem reasonable that the court will afford an opportunity to drill down on the issue of whether or not the abandoning of this case by the fiduciary is in fact a breach of the fiduciary duty, and whether that should be explored further before the court grants the petition to dismiss this matter. So there are one or two ways to do it. And I don't want to waste any time, but one of the ways is the court issue a subpoena as it relates to the fiduciary to bring her in and to understand her position regarding the waiving or exiting of the rights of the protected person. But that almost seems perfunctory, because if in fact this court was to find that she was acting inconsistent with her fiduciary duties under the probate code, then it would go back to probate. So it seems to me that the more that I think about it, the most reasonable thing to do is, if counsel for the plaintiff in this matter tells me that he's going to take up the issue of whether or not it is a breach of the fiduciary's duties to abandon this claim. Then I would give some time to explore that, because I just can't see that unless counsel was to tell me that there's not really a colorable claim here. Otherwise, a fiduciary saying that they're electing to not go forward on a pending claim.
I think that's something we need to do, and I really think that if we do that, it might actually spark, a fire under her feet, and it might, remind her of her duties, and she might start to participate. Or, on the other hand, if she doesn't, then we can get someone else appointed who will do this and adequately represent Mr. Buford as a guardian.
All right, well, we're swimming in some kind of strange waters, because of course I'd like the case to move forward, but yeah, given these set of circumstances, I think that it's completely reasonable and appropriate for the court to allow the plaintiff an opportunity, if they choose to accept that opportunity, to go before the probate court and raise the issue of Ms. Tompkins' proper exercise of her fiduciary duties in this matter. And so I'll go ahead and grant an adjournment in the matter on that issue. I think ultimately the probate court would likely have to pass on the issue of whether or not fiduciary could in fact waive rights in this case. I think the probate court would have to pass on this. If she's not willing to go forward, she says she's not going to do it. I think the probate court would have to sanction that decision. And so that's why I'm stopping things at this point, just to give opportunity to raise that issue. All right. Thank you, Madam Court Report. I got you. All right. So I'm going to go ahead and set it out and bring it back in about 60 days. That's a long adjournment for me, but that'll give you a chance to file a petition in probate court and try to figure out whether or not the court will allow her, that is Ms. Tompkins, to waive the protected person's rights in this case, because that's essentially what she would be doing, right? So the new date in this matter, I'm going to go ahead and set it for the 8th of February, actually, 2/8/23. I'm going to set that at 10 o'clock evening. Obviously,
That works for me, Your Honor.
all right, if you get some traction on both sides before that date, and we can have a meaningful hearing, then all I need you to do is to submit a stipulated document indicating that you like an earlier hearing, and fax that over, email it, or send it in. And as soon as I get that in my hands, I'll set up an earlier date. If you do that, send your email addresses or phone numbers, and I'll get you on the phone and get back sooner than the February date if some traction has been made. That way we don't just have a date out there waiting. So
Understood.
And the other thing that you do, let me just give this to you as well. Because obviously the first thing that would have to happen is the two of you would have to talk and say, well, got some traction, she's ready to participate or whatever. Then we don't have to wait that entire time. You can come back into my Zoom on any day. That Zoom number, the new Zoom number is going to be, because I'm changing courtrooms, so new Zoom number is going to be 360-534. 360-534 and 0000. So after this week, that's the Zoom number that you're coming in. The notice you get will have that date on it, or have that Zoom number as well. But I'm giving it to you now so that if the two of you determine that this case can start moving forward, then just come in on that Zoom starting anytime next week, and let me know that you want to speak with me, and we'll take a moment and set up a date to actually drill down on this and get move forward. Otherwise, the February 8, 2023, 10 o'clock time is the time that the court is adjourned the matter to. And the court finds good cause for the adjournment. I wish both sides well. Good day to you. Best of the holidays.
Thank you, Your Honor. Have a good day, everyone.
Have a good day.
The court now calls case number 19-1511, This is Airbnb Funding LLC versus Donald Gay, the third. The matter is before the court, set on for a status and scheduled conference. The court has received a definitive answer regarding this matter. Your appearance for LBNB Funding, please. You're on mute.
Sorry, I was muted. Sorry. Keith Sparks here on behalf of LBNB Funding P77485.
Thank you, Mr. Sparks, and good morning to you, sir. I'm looking now for Mr. Gay, Donald Gay the third. If you're on the Zoom, sir, please say something at this time. And I'm noticing here, Council, that the notice that I sent out was directed to the Zoom at 534. So that person may be in the 534 Zoom.
I was actually in that room with, I had another hearing at 9:30 or at 9:30. And it was Judge Adams' old court. Yeah. I had another hearing at 9:30 because I thought they were in the same room. He was not there, but you know, there's a dispute on this one. If you want to resend it with, or grant a default judgment, whichever one you want to do.
Yeah, whenever there's a bit of a mix up on the notice, because what I expected was the information that was given to me is that December 1st, I would be transferred to that location. That's why you got that notice. But then they told me that then they changed it just a few days ago and said, well, actually it'll be beginning next week. So that's why we're having this kind of issue. So what I'm going to do is I'm going to go ahead and reset it.
Okay.
Because of the mix up in the notice, and then we'll send out a new notice. So that new date, I'm going to go ahead and set that date up. Now that new date is going to be in January. I'm going to go ahead and set it for January the 5th, 1/5/23 at 9:30. 1/5/23 at 9:30, and we're going to mail that out as well.
Thank you, Your Honor.
Thank you, Council. Good day, Chief. This is case number 22-192-401. This is Estella Huff versus Progressive Marathon Insurance. The matter is before the court, set for a status and scheduling conference. Your appearance for Ms. Huff, please, your appearance.
Yes, Your Honor. Connor Clardy, P84485, appearing on behalf of Ms. Huff.
Thank you, Mr. Florida, and good morning to you, sir.
Morning, Your Honor.
For the defendant in this matter, Progressive, please.
Yes, good morning, Your Honor. Bradley Wing on behalf of the defendant, Progressive Insurance.
All right, and Mr. Wayne, go ahead and put your P number on the record if you will, sir.
Yes, P69812.
All right, thank you, Counsel. Good morning to you as well, sir. So I've got the answer, the responsive pleadings regarding this matter. Have you all had opportunity to talk about this? And my inclination, of course, is to go ahead and set up a schedule on it. But if you think you've got any traction right now, then we can start with that. Go ahead, Mr. Wayne.
We have discussed this a little bit, but I think some discovery just needs to be conducted in order to kind of get a grasp of all the issues that we have going on here. It's a PIP case. Looks like payments have been made, but some payments remain outstanding, and just try to figure out what is owed and what we need to do and go forward from there.
All right, Ms. Florida, it sounds about right to you, kind of line split stuff up a little bit. Go ahead, sir.
Yeah, I think we would need a scheduling order from the court. I will say right now that I have some concerns for my client, and I'm not 100% sure at this point if she's going to need a guardianship, Your Honor, and I don't want to waive attorney-client privilege, but I foresee roadblocks in terms of, for instance, if brother counsel wants a deposition, and I think we're gonna have to potentially reschedule this deposition coming up on the 12th. I'll just say this, I'm worried for her, and I'm not sure what we need to do. So I'm going to explore that in the next week or so. So I would just ask, let's put this on a scheduling track. That way there's some accountability. And then if I need to file a motion, I will do so once I'm armed with more information, and I can make better representations to the court. And I think I just want the court to know, and I want Mr. Wing to know that it's possible that there may need to be a guardianship.
All right, appreciate the notice in that regard. I'm gonna go ahead and set it under my typical scheduling order, which is 60 days. And I'll have you come back for.
Your Honor, normally I'm sorry, I'm not trying to interrupt you.
Yeah, go ahead, sir.
I normally would not do this. I would request if you are willing, Your Honor, to put it on a 90-day scheduling order, just to give me time in case we need to file something with the probate court, or if I need to contact a probate attorney. I would not normally ask for, another 30 days. I think that under the circumstances, that would be helpful.
All right. Well, I'm gonna do, I'm sorry, Ms. Laurie, were you finished, sir?
I am. I'm sorry, Your Honor.
All right, so I'm gonna go ahead and set it for, I'm gonna set it for 2/13/23. I made a note of the issues that you raised, sir. And I'll send it as a pretrial, but a big part of this is that will give me an opportunity to review where things are at that time. And it is noted on record and on my personal note that there may be some issues with competency and so on and so forth, and that may require some additional time, may require exploration of probate options. But I'd like to take a look and see where things are on the 13th.
Yes, Your Honor.
I'll open discovery through that date with the understanding that, as is typically the case, where the parties have been making effort to size up where the case is going, if they need additional time, this court is typically inclined to do that anyway. Also, my order will allow for the filing of motions that can be heard on the 13th of February, so long as the other side has at least 10 days notice of your request. So if you file a motion, give 10 days notice to the other party. I'll hear it on the 13th of February. That's either dispositive or non-dispositive type motions. And again, that paragraph number 6 in my scheduling order will not exclude the filing of motions in the future, but it just gives you on the scheduling order an opportunity, if you see something that you want to get heard on right away, that when you come back for a pretrial on the 13th of February, I'll hear the motion as long as you give the other side at least 10 days notice to respond. All right, so 2/13/23, I'm going to set this on at 9:45 a.m. and it's a pretrial. And as at that pretrial, I'll take a review of the various issues that have been raised in this context in this hearing today. All right, you'll get an order from me in the mail in the next few days.
Thank you.
Well, good day to you.
Thank you, Your Honor. Happy holidays to you, sir.
Likewise to you, Mr. Wayne, as well.
Thank you, Your Honor.
Brad, I'm going to call you if you have a free second.
Yeah, call me right now.
Okay, thank you.
Thanks.
Madam Court Reporter, was that making too much noise for you? Is that what it was, man?
Yes, Judge. Yeah, you were crumpling those papers a bit there.
All right.
Thanks for noticing my message.
So, she said,
I'm working.
yeah,
It could have been.
Ms. Banks said it could have been both of us. We try to work on that a little bit.
Oh, okay.
Oh, this other one, it just a few hours after that time. All right, this is case number 22-24-3100. This is Community Business Consulting versus Lamia Lamia Great House, last name is Great House. The matter is before the court on a claim of appeal. Looks like this was a matter that was heard in the small claims division of this court. Judgment was granted by default on the 26th of September for $444.56. A motion was filed subsequent to that time, seeking to increase the fees that the court allowed. The court then denied that motion for an increase in the process server fees, I believe is what they were seeking. And the defendant appeals from that the court's review of this matter and denial of the motion occurred on September the 30th, 2022. Then it did file a claim of appeal on 10/12/22. Do I have, I should say, plaintiff filed a claim of appeal on 10/12/22. Do I have anyone from Community Business Consulting on this Zoom? Do I have Lamia Great House on this Zoom? You're here, say something. Matter was set on at 10:00 a.m. The plaintiff has not appeared in this matter. The motion and the appeal is denied at this time. So Mr. Neal, why are you here?
Just checking to see that the court received our motion, has entered it, or the conditional dismissal rather.
On which case was that? That was-
Michigan First versus Jones. I see that the court received it on the registrar, but I just wanted to verify that we did need to appear.
It's a mixed Michigan First. It's not on the document. So you must have put in the dismissal.
Okay.
What's the case number?
Give me the case number, Mr. Neal. Let's check it out.
Case number is 22187401 GC.
That's in courtroom 534. We have to check with Renee on that.
Okay, is that my case though?
It don't say, it just say courtroom 534. You probably heard it on that day. They haven't changed. No, this is not. It's actually Judge Nance Adams case. It don't have a, yeah. you just have-
So it's still assigned to the 534. And so what is it? What is the register of action? Does it have anything,
It's saying that if they sent it to the team like they should have, and the team forwarded it up to the court. She just haven't brought those.
Okay, so the order that you, so it
They
shows
have
that
it.
there was an order sitting. Okay, so if you would go in 534 counsel and inquire of the clerk there, because we have on the register that the order was received. I don't know if that file was brought to me yet to sign off on the order. So just check with the clerk. That's there. It's 360534. Because you know I was bouncing between these two courtrooms. Starting
Right.
next week, I 534 permanent.
Will do. Thank you, Your Honor.
Thank you, Mr. Neal. All right, Madam Reporter, I know you hate to leave, but
Yeah. She like, oh.
I know you.